guys, thanks for joining me here. Thanks for joining me. I'm going to do a few questions and answers here. Can you guys hear me all right? Give me some hearts if you guys can hear me, please. Give me some hearts if you guys can hear me. Can you guys hear me all right? Got one over here on YouTube. You hear me all right, YouTube? You hear me here on Facebook? You guys hear me all right? I'm going to assume that you guys do, even though you're not giving me any hearts. Guys, all right, awesome. Okay, so I want to preface right now, we don't have a whole lot of time. Guys, I'm in Portland, Oregon. So if you know someone in Portland, Oregon, if you guys have families here, then reach out to them, let them know that we are here in Portland, Oregon. We're about to do town hall here in Portland. It is today from noon to 4 at the Multnomah County Library, and that's 4040 Northeast 12, I believe. Anyway, it's on the flyer. You guys, you can get out there, check the flyer. And so we're going to be doing that town hall. We'll be streaming it as well. So, 12 o'clock Pacific time to 4 o'clock Pacific time, you guys will be live streaming. And then tomorrow we are down to Oakland, California, guys. Oakland, California tomorrow. So, if you guys know anybody in Northern California, please let them know that we will be at the Oakland Public Library, the Hollywood Library, tomorrow, and that is from 10 to 2. Tomorrow from 10 to 2, and then we're heading back east. We'll be returning to California, so if you're in California and you guys want to make one of these, we will be back. We'll be doing another one the following week in Sacramento, and then down to Los Angeles. We'll be doing 2 on May 3rd in LA and Long Beach. All right, guys. So we'll be in Los Angeles and Long Beach on May 3rd, and then we'll be heading back west again. We won't be returning in any time in the near future. So if you guys are in Portland, Oregon, then please come on out. If you guys have family members that are in Portland, Oregon, if you guys know friends in Portland, then please let them know that we are here to talk to them, collect their affidavits, and help them understand what it is that we are doing. All right. So the next thing I'd like to say, and thank you guys so much for joining me. Thank you guys so much. The next thing I want to say is, be careful what you say right now, okay? Because I'm going to talk to a very, very specific audience. You guys know how I work. We're trying to give information to a very, very specific audience. And so this fight isn't with you guys. But if you come on here and you start saying some silly things, then unfortunately we have given direction to all the moderators that you're just going to be blocked. And I'm sorry, because once again, this fight is not with you. This fight is with the leadership. All right, we're fighting with those powers and spirits in high places, the high court. That is what we're against, guys. So the things I say is focused on them. All right, so please don't be offended by the things I say, and please certainly don't come in here and say something foolish because we will block you. Okay, So I want to start out right now talking about these ALJs. Because I keep hearing from a lot of people, this memo to Grassley and how it's the answer to the question, the answer to our issues. Oh my God, everything is solved now because we've got DOJ that says that these ALJs, they're not real. It's, this is the problem. An ALJ is a hearings officer. So what the memo from the Department of Justice to Grassley, Senator Grassley said, it said that these are not judges, that they're unconstitutional, that they are actually hearings officers, and that they're enforcing policy and not common law, not the Constitution. Now, guys, to understand exactly what we're saying there, right? We can go to what Gorsuch said in his judicial memo, right? So what Gorsuch said in the judicial memo that went out on November 11th, 2023, immediately following me delivering the writ to the United States Supreme Court. Because remember, I delivered it on September 29th of 2023. So I delivered the writ that deals with this issue, you guys. What I'm doing is directly is being responded by the Supreme Court in the Chevron ruling. It's directly being responded by the executive branch in the memo to Grassley. So All judges. So what the ALJ, so what the memo said, remember guys, so what Chevron was all about, the Chevron ruling from June 28th of last year, what it said is it said that basically that for 40 years under the Chevron deference ruling from the United States Supreme Court, it said that for 40 years, the executive branch has been able to look at the law and say, well, it's not clear, it's ambiguous, we need to provide clarity. And then what they would do is they would write policy, right, under the executive branch. They would write policy and then go out and enforce that policy as clarification to the law, right? And so what the Supreme Court said in the Chevron ruling that overturned this particular ruling from 40 years back, and I want to point out one thing before I move on. Guys, mass incarceration. We have seen an 800% increase in the prison population in 40 years. 40 years. Guys, that's the number. 40 years. Tell me, what started mass incarceration but for the executive branch going out and saying, oh, it's not clear as to whether or not I have to have an indictment by a grand jury. Therefore, we're going to write policy and we're going to direct our agents to not put into place the one thing that is there to protect the innocent from hasty or malicious charges from the prosecutor, from the executive branch. What started mass incarceration but for Chevron? But for the judicial branch, telling the executive branch, we're gonna streamline this massacre. We're gonna streamline this, and we're gonna send as many people off, focusing on speed and efficiency as opposed to the constitutional established procedures and processes codified in the Constitution of the United States. The judicial branch, through that ruling, amended the Constitution of the United States, permitting the executive branch to legislate. Thus they did by creating policy that amended the law, they were able to amend the law through their policy and then go out and enforce it as though it's law. That's what happened. And that's what's led to an 800% increase in the prison population, is that we allowed the prosecutors to eliminate the one thing that exists to protect the people from the prosecutor, right? That's nuts. But that's exactly what happened, okay? And that's what's gotten us in the situation that we're in today, okay? But remember, so now the 800% increase happened 40 years ago. So it was the executive branch that's been going out. They wrote policy. They said, oh, it's not clear as to whether or not the Constitution of the United States, under Clause 1 of Amendment 5, requires that we have an indictment by a grand jury. Therefore, we're going to forego it. We're going to charge by information, not by indictment. We're going to eliminate the one procedure, right? The one protection that the innocent have from hasty or malicious charges from an overzealous prosecutor. We're going to eliminate the one thing that exists to prevent the prosecutor from having excessive powers to be able to threaten, intimidate, and coerce people into pleadings of guilt. We're going to eliminate that, and we're going to streamline it. We're going to permit them to amend the law. That's what happened. So Chevron and the ruling that we got back on June 28th, what that did was that said, executive branch, you can't do whatever you want to do. You don't get to create policy and call it law or treat it as though it's law and then go out and force it against the people of the United States, because only law affects the people. The executive branch doesn't create law. They create orders. Orders do not affect the people. Orders only affect those that can be ordered, people of the executive branch. Executive orders don't affect the people. They only affect those that can be ordered. Law enforcement, right? Prosecutors, attorney generals, they all fall under that particular branch of government. Therefore, when that branch of government creates policy and then goes out and enforces it as though it's law, well, guys, just as I've been saying all along, all legislative power is vested in a Congress of the United States consisting of a Senate and a House of Representatives. Clause 1, Article 1, Constitution of the United States of America, all legislative power. So executive branch, you do not get to amend the law. You have no constituted authority to do so. You don't get to create law. You have no constituted duty to do so, right? You don't get to destroy law. You have no constituted authority to be able to do so, because the people of the United States did not delegate any of that authority to the people, to the executive branch. We reserve that to the people through the legislative branch, okay? No one is denying that. In fact, the Supreme Court of the United States agrees with that, which is why they put into place Chevron. That's why they did it. Now, last year, June 28th with Chevron, you all said yourself, you said, oh my God, here is the answer to our problems. The officers, police are no longer going to be able to go out and arrest people for arbitrary and capricious acts, right? They're no longer going to be able to go out and enforce policy and do all these things that's against the Constitution, because guess what? Executive branch, the judicial branch just told you that you don't get to create law. Chevron. Y'all thought that that was the answer to the problems. Y'all thought, oh my God, this is it. Was that it? Huh? Or is the executive branch still out creating policy, right? So the problem that I have with the executive or with the judicial branch is the judicial branch told all of you last June that the executive branch is amending the law. They're amending the law, and they're going out and enforcing that amendment as though it's law, even though it's nothing but orders. Even though it's nothing but policy. Nothing got fixed. So the problem that I have is if the judicial branch controls the judges across this country, and then they created an edict that said executive branch, police, prosecutors, attorney generals, you don't get to create policy and then go out and enforce it, then if those judges continue to work with the executive branch every day, such as they are in these courtrooms, enforcing and administrating and adjudicating policy because nothing's changed, then their words and their actions do not align. And I keep telling you guys, I was trained in lie detection. That's what I did for many years, right? I've been trained to deal with liars, to identify liars and to address liars, right? Words and actions are the primary way of determining whether or not a person is a liar. If they say one thing, but they do something different, they are a liar. The judicial branch said they're criminals, they're unconstitutional, they've been doing all this shit, but you know what? We're not going to change anything. We're going to continue to work with them. What the judicial branch was doing there was the judicial branch was preparing to place the blame onto the executive branch for this indictment issue, right? This is a big deal. Today, there are more than 700,000 people currently imprisoned across America on direct facial constitutional violations because these states did not have an indictment by a grand jury before arresting someone, holding them over for a capital or an infamous crime in accordance with Clause 1 of Amendment 5 to the United States Constitution. Information is not an indictment. An indictment goes in front of a grand jury to determine whether or not there's probable cause to assume that a crime has been committed. So what happens there, just as you all have said, oh, police officer, you're supposed to take me in front of a magistrate. Immediately, you're not supposed to take me to jail. You're supposed to take me in front of a magistrate. Is that not what the law says? Is that not what all of you have been saying? Why are you supposed to be taken in front of a magistrate? Because that would be the process of the grand jury. There is a grand jury convened in every single United States district court across the country. There's supposed to be one convened in every single state court across the country. And you're supposed to be immediately taken to them. Why? Well, just as the Supreme Court said in Beck versus Ohio, 1968, that good faith alone cannot determine, or subjective good faith alone cannot determine probable cause. If subjective good faith alone were the measure, then we would be secure in our persons, properties, papers, and effect by the discretion of the police. We don't want to be secure at the discretion of police. Therefore, there must be a neutral, unbiased decision maker to review the accusations against you from an agent of the state, the police officer, the prosecutor, before you can be treated as though you're guilty. This process is designed to protect the innocent from hasty or malicious charges from an overzealous prosecutor or law enforcement officer. But you do not go in front of a judge to determine probable cause, such as they do today with information, because that judge has an automatic, mandatory, self-executing duty to recuse himself under Title 28, subsection 455, because he is an officer of the petitioner, right? Of the movement party. When the state takes a side against you and it brings accusations against you through any one of its agents, that judge has a mandatory, self-executing, non-waivable duty to recuse himself under Title 28, subsection 455. Go out and read it, you guys. Go out and read it. Judges may not be both judge and party in the cause, because the judge represents the very same body of men bringing the accusation against you. This is the heart of the argument that we're litigating. This is everything I'm doing, going across the country to try to explain to all of you, right, that there must be a neutral, unbiased decision maker that's going to review the accusations against you to determine whether or not there's sufficient probable cause to assume that a crime has been committed. And if you deny the accused the right to be present, to confront those accusations, those hearsay accusations against them in the proceeding that exists for the protection of the accused from the very person that denies them the right to be present, then that also is an abusive process. And that is 99% of all cases across this country. The accused must be present in that grand jury. Must be present in that grand jury. Right? And when you deny the accused the right to be present, when the prosecutor hinders and obstructs free speech so that they can control the narrative, so that they can secure an indictment as though it's a fucking ham sandwich, because they bring any arbitrary or capricious hearsay accusations that would not even be admissible in the petit jury, when they do this, what they've done is an abusive process. What they've done is a violation of the law. Conspiracy to obstruct justice, because they are obstructing the due course of the administration of justice. It is a skewing of the disposition of a legal proceeding so that they can control the narrative and prevent half of the party from being able to tell their side of the story. Guys, I've been saying this for a long time. Truth will always lie somewhere between two stories. But when one side is heard, right, and that one side, their counsel or their attorney or their representation is the prosecutor, and that prosecutor then denies the opposing party the right to be present to benefit from the proceeding that exists for their protection from the prosecutor, well, it doesn't take a rocket scientist to understand that that is an abusive process and a crime. And by that criminal act, by the conspiracy to obstruct justice, because when the prosecutor conspires by and between the accuser to deny the accused the right to be present to benefit from the very proceeding that exists for their protection, that crime negates the validity of the indictment. So even if you got an indictment, right, even if they indicted you before they arrested you, that indictment is void because it derives from a criminal act committed by government agents, when they denied you the right to be present to benefit from the very proceeding that exists for your protection. If you want to know where that particular enforcement statute comes from, conspiracy to obstruct justice, go to Title 42, subsection 1981. That's the civil act that created the obligation, and then they created the enforcement statute that says when two or more persons conspire for the purpose of preventing any party in any cause from participating in said cause commits that crime. What 1981 says, it says all persons within the jurisdiction of the United States shall have fair and equal benefits of all laws and all proceedings. This is the heart of the egalitarianism system that we live within, right? The heart of it. Because all men were meant to be created equal, therefore laws must apply equally to all men. So we created 1981 to say all persons within the jurisdiction of the United States shall have fair and equal benefits of all laws and all proceedings. The Fifth Amendment is a law created by the United States of America. We, the people, created that. Therefore, it is a restriction to the states from interference, right? States cannot interfere with that because we, the people, delegated it to the central government. Therefore, it's restricted to the state government, okay? States cannot interfere with it because it's restricted, because it's preserved and enumerated within the Constitution of the United States of America. So therefore, the Fifth Amendment is a law created by the laws of the United States. Therefore, it is protected by 1981. The grand jury is a proceeding created by the Fifth Amendment. Therefore, it too is protected by 1981. No person or all persons within the jurisdiction of the United States shall have fair and equal benefits of all laws and all proceedings. No state may interfere with the Constitution of the United States, and no state shall create or enforce any laws that interfere with the proceeding of the grand jury, because it's protected by 1981 through the enforcement statute of conspiracy to obstruct justice. So when the prosecutor conspires by and between the accuser to deny the accused right to be present, to confront the hearsay accusations against them in a proceeding that exists for the benefit and protection of the accused, and they're being denied the right by the very person that the proceeding is designed to protect them from, all these indictments are unconstitutional, because they all derive from an unlawful act. Remember, maximum law. Any act unlawful at the beginning cannot become lawful over time by subsequent legislation. That's why I'm collecting these affidavits, you guys. Because every time that you've been arrested, right? Every time you've been arrested by these policy enforcers, right? Whether you had an indictment or not, right? Whenever you do, right? I'll have to come back on this, okay? So I'm trying to get you guys to understand that if your arrest is unconstitutional, if your arrest derives from an unlawful act, then all that we have to do is point out the unlawful act, the unlawful arrest, the unlawful detainment, and when we show that a crime was committed in order to arrest you, then everything deriving from that arrest must also be unlawful, must also be unconstitutional, because it's all tainted by the illegality of the way in which it was obtained. This indictment issue, this issue alone will mitigate and eliminate and render void every single one of your judgments. It doesn't matter if there were lies from police officers. It doesn't matter if there were lies from prosecutors. It doesn't matter if there was fabricated evidence. It doesn't matter if they excluded exculpatory evidence. It doesn't matter whether the judge is biased. All of that is after your arrest. After your arrest. If the state did not have the authority to make the arrest because they didn't follow the proper procedures for the arrest, because they didn't have the proper documentation in accordance with the law, the highest law of the land, then everything that derives from that arrest must be unconstitutional. Must be. Okay? So if you guys continue to talk about the rules of evidentiary procedures, if you guys continue to talk about the biased judges or the lies of the prosecutor, if you continue to talk about those things, you are going into an area that's after the arrest. You are going into an area in which they can arbitrate an issue. You are giving them the ability to take control of the case and deal with it. No, the state, the officer, the prosecutor committed a crime when they arrested you because they did not follow the proper procedures, because they wrote policy, right? And called that policy law and went out and directed all their agents to follow their policy. And that's led to an 800% increase in the prison population over the last 30 years, right? That's where we're at. If you guys will stop and you'll listen to what I'm saying, and we go to the arrest and we deal with the arrest, you allow me to be your advocate, you allow me to litigate this for you finally, right? I will void your arrest. I will render your arrest unlawful, and everything that comes from that is fruit of the poisonous tree. Because if you perform an arrest that's unconstitutional, then everything coming from that arrest must also be unconstitutional. There is nothing that any one of you have to appeal, because there is no judgment. Because that judgment, whether it was a plea bargain, whether it was a trial, every bit of that is all void. It doesn't exist because the arrest was unconstitutional. This is the heart of the issue. Every single one of you can talk about the exact same issue. The moment that the states went out and performed an arrest without lawful authority to perform that arrest, because they did not follow the constitutional parameters codified and enumerated within the Bill of Rights, when they did that, everything after it is unconstitutional. But now going back to my original issue here, because I want you guys to understand what's going on right now. Yes, I want you guys to do the affidavit, but it must be my affidavit. Let me clarify for you guys, okay? You must use my affidavit. And if you don't have a copy of the affidavit, then reach out to us, reach out to myself or Justice Without Limits, all right, on TikTok. Jessica Saxton on Facebook. You guys reach out to her or reach out to me. Guys, I know I'm not good at replying. I've got so much going on, right? You guys got to understand, right? I'm litigating on behalf of 2.9 million people right now. 2.9 million. We have 2.9 million people. We have 10 million people that many of them don't even know that I'm fighting for them. Many of them have no clue who I am, and it doesn't matter, but I'm fighting for them, right? I'm fighting for all your families because same thing. When the state chose to take a child without having the proper authority to do so, everything that they've done after that, including an adoption, including a TPR hearing, all of it is void because the removal of the child was in violation of the Constitution of the United States of America. We don't need to talk about anything else. We don't need to talk about the adoption. We don't need to talk about the TPR hearing. None of that matters. All we got to talk about is, did the state have the authority to interfere with the right of intimate association and take your child from their family? The answer is no. Absolutely not, right? That's the point that we talk about. That's why the habeas corpus is dealing with the familial issue. That's why I'm litigating this on behalf of the families every bit as much as on behalf of the prisoners, right? One question, one action, every prisoner. Every prisoner. The children are prisoners. The adults are prisoners. The guardianships are prisoners. They're all prisoners. And I'm litigating on behalf of all of them. And if you guys can understand this and grasp this and get behind me, then we can get this shit done, right? We can get it done. We can get it over with, okay? But here's the thing, okay? Once again, Chevron was all about the judicial branch pointing their finger at the executive branch and saying, you're going to take the fall for this. You're going to take the fall. This is going to be your fault, okay? Because prosecutors, you're bringing the incorrect charging instrument into the judges, and the judges are, they're complicit in it because of their negligence, but the prosecutors are responsible for this crime. That's what they did. That's what Chevron is all about. But once again, the problem that I have is that even though they did that, did their actions align with those words? And the answer is no. Because every day, these judges, these ALJs, whatever the fuck you want to call them, every day, they're back in that courtroom working with the executive officers. Every day, they're back in there doing business as normal, which means that they say that they're unconstitutional, that they're enforcing unconstitutional laws, but guess what? The judicial branch is continuing to administer those unconstitutional laws, right? Every one of them, all right? So there's number one. Words and actions aren't aligning. Now, there's another words and actions that you guys are not getting, and this is the heart of the issue. This is what I want to talk about right here. This is what I want to inform you guys. I want you to open up your eyes to this, all right? Because you guys still are not understanding this, okay? Words and actions must align. You guys are blinded by certain groups, by certain people, by certain, politicians. You're blinded by the words that they're saying, and you're not looking at their actions. Let's start with the judicial branch. We had the Chevron ruling on June 28th. Of last year, June 28th. And that was all about executive branch. You cannot do whatever you want to do. You cannot do whatever you want to do. That's what it was about. Executive branch, you've been creating policy because you thought that the law was ambiguous. You've been bringing us in the incorrect charging instrument. Well, you know what? We are no longer going to participate in that criminal conspiracy. That was the affirmative action coming from the judicial branch to the executive branch, notifying them that they will no longer participate in that criminal conspiracy, which is the only way that the judicial branch could mitigate their culpability within that criminal conspiracy. It's the only way. But the very next week, the judicial branch, the United States Supreme Court, came out in another case called the Trump immunity case, and they said, executive officer, you can do whatever you want. And the problem that I have right here, you guys, you're not looking at words and actions. 1 week, executive branch, you cannot do whatever you want. The very next week, executive officer, you can do whatever you want. Those two rulings do not align with one another. They don't make sense with one another. None at all. That's why I was so concerned back on July 4th. That's why I had to leave DC, because the day that ruling came out, the Trump immunity ruling, I was very concerned about the situation, because I knew as of that moment, words and actions didn't align. Supreme Court was lying about something, and I didn't know what they were lying about until the DOJ memo came out, right? The DOJ memo came out and it went to Grassley. So now we have the executive branch, right? Because that's DOJ, part of the executive branch. We have the executive branch that wrote a memo to Senator Grassley and said all of these judges are all hearings officers under the executive branch, right? They're all ALJs. They're all hearings officers. They all work for the executive officer, right? They're not judges. They're hearings officers. They are ALJs, right? They're not judges under the judicial branch. And we saw that memo come out. And now all of you are running around the country and all over Facebook and all this other shit, and you guys are so blinded by what they're saying that you're like, here's the answer. We got it right here. This is the answer. Well, you know what? It's not the answer. Because is not the prosecutors and the attorney generals still going into that courtroom every single day and continuing to work with these judges, with these ALJs? Is it not business as normal out there for all of you? You guys, you want to look at their words, but you don't want to see their actions. You want to believe what they say and say, oh, this is the answer. But you know what? Is it the answer? Have they changed anything? Have they corrected any of this? Or is it business as normal? It's business as normal. So once again, they're lying. Just as I said before, they're lying because their words and their actions are not aligning. And if you guys can't grasp this, if you guys can't understand this, then listen, you guys are going to be blinded by these diversions that our government creates. Remember, I was one of the best at creating these. I did this for our government. This is what I did for a living. They taught me how to do this. And that's what they're doing. They're creating a diversion. They're trying to get you to believe that these judges are not judges, that they work for the executive branch, and that they're just hearings officers, and that they're no longer going to protect them. Well, if they're executive officers and they're not judges, then wouldn't that mean that the executive officer could just tell them all to stop doing unconstitutional things? If they work for the executive officer, then wouldn't the executive officer just say, well, you know what? Don't do it anymore, right? Why would he need to write a memo to Grassley saying, hey, Grassley, all of these people that work for me are all unconstitutional, but I'm going to continue to allow this unconstitutional work to continue to occur in the courtroom every single day across this country? You guys are not asking these questions. You're not asking why their words and actions don't align. Why? What are they lying about? Let me tell you what they're lying about. Let me tell you what. And once again, you guys got a problem with what I say? Great. You guys want to make stupid statements? We're going to block you. All right? But I want you guys to know the truth, because it's so important that you know the truth and you're not blinded by this bullshit that they continue to throw at you to get you looking in the wrong direction. These diversions that they create, little looky-loos to say, oh, here's the answer. They're not judges. We all know that they're not judges. But you know what? If you believe that they're not judges, right? If you buy into that narrative, if you accept what they're saying to you, then the executive officer can grant his agents immunity. Because last year, the executive officer was given immunity. Therefore, he can grant all of his officers immunity. Right? And if he grants all of his officers immunity because he was given immunity, then guess what? They just found a way out of this. Not through this, but out of this. They just found a way to make all of this go away. If you believe the bullshit that they're giving you. If you believe that these are hearings officers that work for the president, then guess what? The president can continue on business as normal because he grants immunity onto his agents because the Supreme Court of the United States said, executive officer, you got immunity. If you buy into this narrative, if you accept the diversion that our government is giving to you, and you don't look at the words and actions and see that it is business as normal in every single court across this country on what the judicial branch has said is unconstitutional and what the executive branch has said is unconstitutional, and yet they continue to act unconstitutionally every single day, you're just gonna be fools. You're gonna end up being nothing but a bunch of fools, and you're gonna feel foolish when the curtain is opened up, lifted, and you realize that everything that they're doing is now immune, right? Is now protected because the executive officer has granted immunity onto all of his agents. This is the way we're going to combat this, you guys. This is the way that we're going to combat it. I use the analogy of water gun. Water gun. It's as simple as this, right? Water gun. If I'm walking down the street and I have a water gun, and I walk up to this with this water gun, I pull it out and I point it at you and I say, give me your money or I'm going to shoot you. I am portraying that water gun as real. And if you believe that it's real and you give me your money, then guess what? I'm going to prison for robbery. Because I portrayed it as something and you believed it to be what I portray it as. Therefore, I've created a contract for your money through the use of immediate bodily harm because of the weapon that I brought. Whether it's real or not is irrelevant. What matters is how I portray it and how you believe it and whether or not you entered into a contract through the use of coercion or duress. Right? That's the one thing. Do you believe it's real? And if you believe it's real, because I portrayed it as it's real, then we have created a contract through the use of duress, and duress can never be the formulation or the basis of formulation of contract. Okay? When you walked into this courtroom, you guys, any one of you walked into that courtroom, did you believe that that person portraying himself as a judge and that told you he was a judge, did you believe that he was anything short of a judge working for the judicial branch? Did you believe he was a hearings officer working for the President of the United States? Did you believe that he didn't have the authority to call you into that courtroom or to do anything, against you because he was just nothing but a hearings officer? Did you believe that? No, because no one will go into that courtroom if they believe that that person doesn't have the authority to be able to call him into the courtroom. Every one of you believed that that was a judge, just like the water gun. Everyone believed that it was a water gun. You believed that that was a judge. You believed that he had certain rights or certain powers to call you in. And even if he was a hearings officer, even if he did work for the executive branch, do not buy into that narrative. Do not accept that narrative. No, that was a judge. He portrayed himself as a judge. The judicial branch never corrected him. He told you he had certain powers, and you entered into contracts with him based upon the abuse of power, the duress that he inflicted upon you, someone that had no authority to be able to do it. If you don't buy the narrative, and if you continue to say, oh no, that's a judge. That was a judge when I walked in that courtroom, because that's what they portrayed him as. That's what he claimed to be. Therefore, it's up to me to decide. If you push that, and if you maintain that, we can get through this bullshit that they're trying to create to you, right? They're trying to get you to look in a different direction, to accept the narrative that they're feeding you, right? So that you all, everything that they've done will be valid. Okay? Do not buy into that. Don't buy into it. If they portrayed themselves as a judge, just like if I portrayed it as a real gun, and you believe that they were a real judge, just like you believed it was a real gun, a crime has been committed. Contracts were entered into through the use of duress by someone that had no authority to be able to do it. And if they're judges, they have no immunity. They only can have immunity because the Supreme Court can't give themselves immunity. They had to go in and do it to the executive branch. They had to do that because that was the only way that they could get out of this. But here's the problem, executive branch. You don't see the trap that they're setting for you, Mr. President. You don't see that they're setting a trap. You're going to take the fall for this. They're lining you up to take the fall. They're going to say all of your prosecutors and all of you attorney generals, you're all traitors, because that's what they set up against you in the Chevron ruling. You don't even see that you're nothing but a puppet to the judicial branch. The Supreme Court is pulling all the strings, Mr. President, not you. You're not pulling shit. They're pulling the strings, right? And you're buying into their bullshit just as much as anyone else, right? You accepted the quid pro quo that they gave to you on June 2nd. You know that you did. And now you're protecting them by saying, oh, I've got immunity. I'm going to continue with this business as normal, right? I'm going to find a way to get this business through, right? Here's the problem, Mr. President. It's not your fault. Your prosecutors are bringing the incorrect charge and instrument. Your attorney generals are absolutely traitors because of their negligence. But guess what? It's the judicial branch that's committing the crime and not your agents, the judicial branch. Because the Fifth Amendment to the United States Constitution says, no person shall be held to answer for capital or otherwise infamous crime unless on presentment or indictment of a grand jury. Again, no person shall be held to answer. Who makes the decision to hold someone over? It's not the prosecutor. It's the judge. So who commits the violation of the Constitution? It's the judge. It's the judicial branch. They're responsible for this, right? They're responsible for this. So yes, the prosecuting attorneys are bringing the incorrect charging instrument. They cannot bring information. They cannot abuse their discretion in order to break the law, because that would be abuse of discretion. They cannot follow policy, that's written by the executive branch. They can't do these things, but they're not the one committing the crime. The crime is committed by the judge the moment a person is ordered to be held over for a capital or infamous crime without an indictment by a grand jury. Crime is being committed by the judge. But unfortunately, prosecutors, the moment that judge commits a crime based upon you bringing the incorrect charging instrument, now a conspiracy by and between the judge and the prosecutor is established. So neither one of you are going to get out of it. But executive branch, if you want to take the fall for this, go ahead and take the fall for it. And all your prosecutors are going to be the first to fall. You can allow the judicial branch to get over on this, even though it's the judicial branch that's lawfully obligated to make sure that there's an indictment by a grand jury before he orders someone to be held over for this offense. The judges are committing the crime. You guys are complicit due to your negligence in the criminal conspiracy. But I'm telling you right now, you can mitigate your culpability within a criminal conspiracy according to law in one of two ways. One of two ways. Can you please block MW? He's an idiot. Thank you. So you can mitigate your culpability in one of two ways. First off, you can mitigate your culpability with the criminal conspiracy by notifying the authorities of the crimes. Right, notifying the authorities of crimes. Okay? So I'm going to tell you right now, I've gone around the country and I've served 43 state attorney generals. 43 state attorney generals with actual crimes that their agents are committing. Not one of them mitigated their culpability within the criminal conspiracy at all, because the state doesn't get to investigate the crime of deprivation of rights under color of law. According to law, the only agency that can investigate deprivation of rights under color of law is the FBI. FBI. That's the only law enforcement agency that can investigate deprivation of rights under color of law. So, attorney generals, when I provided you notice of crimes that are being committed, the only way that any one of you could mitigate your culpability within the criminal conspiracy is to forward that on to the FBI for investigation. And not one of you did that. No, you all said, oh no, we're not going to investigate this. That's what you guys did. And guess what? You guys fucked up. You fell into the trap like a bunch of fucking idiots. Attorney generals, you're all just a bunch of idiots. Because you don't get to make that decision. The law says that you must forward that on to the FBI. Now, FBI obviously wouldn't have investigated either. I knew that. But you all had to forward it on to the authorities for investigation. That was the only way you at state attorney generals could have mitigated your culpability within this criminal conspiracy, is to forward it on to the authorities. Notify the authorities of the crimes. 43 attorney generals did not do that, because you all thought that you had the authority to be able to investigate this crime, and you didn't. You're a bunch of idiots, right? So guess what? We have 43 state attorney generals that did not mitigate their culpability within the criminal conspiracy, that are now members of the criminal conspiracy. But guess what? You still have a little bit of time, you fucking idiots. Still have a little bit of time. Okay? So you still have a little bit of time, because by the time I make it back to DC, if you guys haven't done what you are obligated to do to mitigate your culpability within the criminal conspiracy, then you're all going to be having long necks, right? We've talked about that, right? What is the ramifications of your treasonous acts? Well, you know exactly what those ramifications are. If you don't think that's going to happen, if you think that the American people are docile, well, you're going to have a rude awakening here very, very soon, because we are not docile. We're not going to stand by and allow you to, as a criminal, as a traitor, to destroy our country, rob from us, steal our children and our property. We're not going to allow that. I mean, you know, every single democracy in the history of the country has been destroyed at the hands of people because of you, government tyrants, right? Go ahead and read history. You want to fucking understand history? Go ahead and, you know, it'll tell you exactly what's about to happen. And it's not anything that should be a shock to any one of you. So, attorney generals, you have a little bit of time left. But the only way that you can mitigate your culpability within the criminal conspiracy is you must forward on the affidavits that I gave to you, the service that I provided on all 43 of you. You must forward them on to the proper authorities for investigation. You must send them up to the FBI and ask the FBI to investigate these crimes, because it's not up to you to do it. The law states that the only way you can mitigate your culpability within the criminal conspiracy, once notified, is one, notify the authorities of the crimes. State attorney generals, you better notify the authorities, the FBI, of these crimes. You better do it, because if you don't, then you have not mitigated your culpability within the criminal conspiracy. And the other way to do it is you must notify your co-conspirators of your intent to no longer participate, but that must be done by some affirmative action. Supreme Court of the United States, we're fully aware that you notified your co-conspirators, the executive branch, right? We're fully aware that you did that in the Chevron ruling. That was your affirmative action, notifying them that you're no longer going to participate, and yet you continue to participate with them every single fucking day across this country in every single courtroom, right? That's not mitigating your culpability. Notifying your co-conspirators of your intent to no longer participate means you will not participate anymore, right? Supreme Court of the United States, if you continue to participate with these unconstitutional acts, if these judges or if these prosecutors and attorney generals continue to bring to you informations and not indictments, and you continue to permit your agents to work with them, you have not mitigated your culpability within the criminal conspiracy. You are still traitors. You can put out all the rulings you want, but if you continue to act unconstitutionally despite the requirement to mitigate your culpability, you're still traitors, and you will still be held criminally liable for your treason against the people of the United States in the same way that we're going to hold the prosecutors and attorney generals liable. So right now, you guys, all you got to do right now is pull your head out of your ass, listen to what I'm saying, decide which side of the law you want to be on, and you better do it within the next 37 days, because I'm coming back to Washington, D.C. with 500,000 criminal affidavits on behalf of people in the United States for their deprivation of rights and freedoms that have been robbed from them by you public officials who are nothing but a bunch of liars. Because you can say that you're honorable, you can portray yourself as honorable, but when you're acting in a treasonous manner, refusing to enforce the body laws governing this nation after swearing by oath or affirmation to do so, that makes you a traitor. Right? And the whole country already knows that you're a traitor. You guys can put out all the memos you want. You guys can put out all the fucking bullshit rulings you want, but if you continue to act unconstitutional, or you continue to participate in unconstitutional acts, it doesn't matter. All the honor you say you are, you're nothing but a criminal. Every single fucking one of you. Every single one of you. And it's the Supreme Court of the United States. You guys are directing all of them. Because guess what? The crime is being committed by the judges. The judges work for the Supreme Court of the United States. Supreme Court of the United States, 37 days, I'm going to be back there with 500,000 criminal affidavits on behalf of actual victims, people of the United States, for treasonous acts committed by you, under your authority, under your watch, by your agents. We'll see what happens then. I would suggest that you guys get this addressed before I get there. Guys, thank you so much. We got to get moving. Portland, Oregon. You guys know where I'm at. Portland, Oregon. I'll be here all day. Come on out. You guys got a problem with things to say? Come on out. Okay? Please continue to like, follow, share. Please comment if you guys can. Donate. Guys, we need the donations. I cannot do this work without your help. I don't get paid for the things that I do. I'm doing this because these 2.9 million prisoners, right? These 2.9 million prisoners, they don't have the money to be able to get help. They don't have the money to do it, right? So I'm helping them because it's the right thing to do. I'm helping them because they need someone like me to fight for them, and we're going to continue to fight for them. right? Until either one, that army retreats or God sends me home, right? Those are only two ways that I get out of this. We have Cash App, Chime, Venmo, PayPal. They're all exactly the same. Guys, I need $1,000 by tomorrow night, in order to continue on. The tour route has been published, right? It's published. Tomorrow we're in Oakland, and then we've got the route going around. I'm coming to these states. I'm sorry if I'm not coming to your state, but just remember, guys, just remember, I have to do the greatest bang for the buck. That's why I have so many stops in California. That's why I have so many stops in Texas. And that's why I have so many stops in Florida. Texas and Florida represent the highest numbers of incarcerated people. Obviously, those are locations that I need to hit the hardest, right? So I'm sorry if I'm not coming into Grand Island, Nebraska, right? Or I'm sorry if I'm not coming into Fargo, North Dakota. But those locations, they are not the greatest bang for the buck. I would love to meet you guys, but I only have so much time. I only have so much. So you guys, please, if I'm coming to your state, get out. Get out and talk to me. But if I'm not, I apologize. We'll get the opportunity to meet. But first things first, we got to address this situation with this government. And that's what I'm trying to do, okay? Trying to do that for you guys, all right? I'll be in New York, but it's going to be New York City right now. I will be in Concord and Montpelier, which is fairly close to upstate, but right now we're not, okay? So all that I can say is that I'm stepping up, right, on behalf of the people of the United States to stand against those that are acting and warring against the people of the United States, and I'm giving them an opportunity to decide if they want to be criminals, then continue to do what you're doing, right? In which case, we will hold you accountable for your crimes. But you guys, this has nothing at all to do with politics. This is not red or blue. I had a conversation with someone just the other day, and they were talking about the current administration. And just understand, I'm naturally conservative. But the problem is, once again, I've been trained to identify liars. Words and actions. I know liars. I identify them. That's what I do. I address liars. That's what I was trained to do. So I want you guys to understand that what the current administration is doing with Doge is focused on money. The money is being wasted by the blue states. All the blue states are wasting money because that's what's happening. So the current administration is focused on money and the wasting of money. But I want you guys to be brought to the attention of this, that the red states represent the highest rates of incarceration. Why? Because they're not worried about spending the money. They're worried about generating the money. Texas and Florida and Oklahoma represent the three states that is stealing the most children, that are locking the most people up, and they're doing it because that advances the business. That generates revenue for the business. So we have an issue here where everybody keeps saying, oh, it's about this side or this side. And I'm telling you guys that both sides are against the things that you guys need. One side, the current administration, is about advancing the business. That's why Trump signed an executive order that expanded the private prison contract the moment he was brought in office. Okay? Right? That's why they are still continuing business as normal, because the business makes slaves. The business generates revenue. There is only one post office box remaining, right? And that's the one in North Carolina. It's the only one. So you guys, are going to continue to send in affidavits. We will continue to accept them for another 37 days. You must send them to the North Carolina post office box. Must go to the North Carolina post office box, all right? So if you're here in Portland, come on out. Please like, follow, share. Please show your support. Please donate. It's very, very important we get your donations, because I cannot do this without your help. I need $1,000 before tomorrow, or else we will not be able to continue on with this route. Okay, so please come out. Please donate. We have Cash App, Chime, Venmo, PayPal, and they are all exact same. So we shall be free. That's the only one we have. We shall be free. Please go ahead and block Bob. right. So thank you guys so much. Have a great rest of your day. And again, Cash App, Chime, Venmo, PayPal, they're all the same. We shall be free. Hope to see you guys out here in Portland or Oakland today and tomorrow. Thank you guys so much. God bless. Have a great rest of your day. Thank you, YouTube. Appreciate everything you've done here. Thank you.